In July, Judge Eileen Cannon dismissed a criminal case charging former President Trump with hoarding classified documents at his home in Mar-a-Lago. Judge Cannon held that the prosecutor in the case, Special Counsel Jack Smith, was not properly appointed by the Justice Department. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. In this episode of We the People, we'll explore the merits of Judge Cannon's decision, as well as the constitutional and statutory basis for the Special Counsel. Joining me to discuss this question are two of America's leading constitutional scholars, both of whom argued before Judge Cannon on this central question, and it is such an honor to convene them today. Matthew Seligman of Stanford Law School and Josh Blackman of the South Texas College of Law, Houston. Matthew Seligman is a non-resident fellow at Stanford Law School. He was previously a Clemenko Fellow and lecturer on law at Harvard Law School, a fellow at the Center for Private Law at Yale Law School, and a visiting assistant professor at the Benjamin and Cardozo School of Law. Matthew filed a brief in Judge Cannon's court. Matthew, it is wonderful to welcome you to We the People.
Thanks so much. It's wonderful to be here.
And Josh Blackman is the Centennial Chair of Constitutional Law at the South Texas College of Law, Houston. Josh is also an adjunct scholar at the Cato Institute and has written 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Josh also filed a brief in the case. Josh, it is wonderful to welcome you back to We the People.
Thanks for having me back, Jeff.
Let's begin with Judge Cannon's opinion, questioning the constitutional basis of the special prosecutor. Matthew, what did Judge Cannon hold and what was her reasoning?
Judge Cannon held that the special counsel, who is an inferior officer under the Constitution, and I'll explain what that distinction means, was not lawfully appointed by the Attorney General Merrick Garland. The relevant constitutional provision is the Appointments Clause of the Constitution, and cases over the decades have created a tripartite distinction between principal officers, inferior officers, and then mere employees. And that covers the field of everyone who works for the federal government. The distinction between principal and inferior officers is critically important to Judge Cannon's decision. The Constitution requires that principal officers be appointed by the president with the advice and consent of the Senate. Now, for inferior officers who have some lesser degree of authority, the Constitution gives an option. By default, they still have to be appointed by the president with the advice and consent of the Senate. But if Congress passes a law, it can vest that appointment power in the head of a department, like, for example, the Attorney General. Now, since the special counsel is an inferior officer, at least that's what Judge Cannon held, and there's precedent from the Supreme Court that indicates as much. The question then is whether Congress has passed a law that says that the Attorney General can appoint the special counsel as an inferior officer. Because if it hasn't, then still the default option is that the president has to appoint the special counsel with the advice and consent of the Senate. So this is a constitutional question that ultimately comes down to a statutory question. What laws has Congress passed, and do those laws give the Attorney General, Merrick Garland, the authority to appoint the special counsel?
Thank you very much for that introduction. Josh, what would you add to the question of what Judge Cannon held in striking down the special prosecutor?
So what's interesting here is that the judge didn't actually make a ruling on the Appointments Clause of the Constitution, which Matt mentioned a moment ago. Was Jack Smith a principal officer or inferior officer? She kind of just assumed, for argument's sake, I will assume he's inferior, but I don't think she believed that, but she'll just assume that for the moment. Trump's lawyers argued that, in fact, Smith was a principal officer who would have to go through the Senate confirmation process, but the judge didn't rule that. There was another issue involving the Appropriations Clause. That is, did Congress, in fact, appropriate money for Jack Smith's position? Now, there's a statute. The statute was basically passed in the late 1980s, saying that there's basically a permanent pot of money for the independent counsel. And Trump's lawyer said, aha, that applies to the old independent counsel that existed before the 1990s. Doesn't apply to sort of this new special counsel that Jack Smith is operating under. Cannon hinted and suggested that there too is a problem, that there's no funding for Smith, but she didn't rule that way. Her opinion, as sort of long as it was a long decision, actually focused on a fairly narrow issue. Was there an office to which Jack Smith was appointed? In other words, did Congress create a position for Jack Smith? And Trump's lawyers and several of the amicus briefs argue that no, they did not. And then because Smith doesn't have this office, he is in fact a private citizen. He's no different than you, me, or Matt. And I think, Jeff, if you tried to indict someone, a judge would laugh at you and say, "Go away, Mr. Rosen." And that's basically what Judge Cannon said to Jack Smith. You are a private citizen. You hold no government office. You can't indict the president. Come back with a real U.S. attorney, and then we'll talk.
Thank you so much for that. So on Monday, Jack Smith filed an appeal in the 11th Circuit, arguing that there's a clear statutory basis for his appointment as special counsel in 28 U.S.C. 533. That's a number that came up frequently, and also in other provisions of the U.S. Code. He said that the Supreme Court has already decided this question in Nixon versus U.S. and said there's a long tradition of special counsels being appointed under these statutes. Matthew, can you describe the basis for Jack Smith's appeal?
The special counsel's appeal is grounded essentially in two sources of authority. The first is the Supreme Court's decision in United States v. Nixon, and the second is the statutes themselves. So first, United States v. Nixon was a case about Richard Nixon and the special prosecutor that was appointed to investigate the Watergate break-in. And when the special counsel subpoenaed documents from the White House, President Nixon resisted that. He said that there were separation of powers issues between, well, the special prosecutor works for me because I'm the president, and so how can he subpoena me? And so that's how the issue was framed in United States v. Nixon. In the course of that decision, the Supreme Court said that the special prosecutor had been appointed pursuant to a set of statutes. Those statutes are sections 509, section 510, section 515, and section 533. And these are exactly the same statutory provisions that the special counsel relies on now. There is no real difference between the quote-unquote special prosecutor in the Watergate investigation and the special counsel now. So the special counsel argues this issue has already been decided. The Supreme Court already said that a special prosecutor / special counsel can be appointed by the Attorney General. The special prosecutor in the Watergate investigation had been appointed by the Attorney General. And both the special prosecutor and the special counsel now are inferior officers, and the statutory authority is exactly the same. So the Supreme Court already decided this issue. So the lower courts, Judge Cannon and now the 11th Circuit, are bound by that decision. There are arguments about whether that statement in the United States v. Nixon is dicta binding, holding, or dicta, and I'm sure we'll talk about that. But that's the argument that the special counsel gives. And then moving on from precedent, the special counsel argues that, well, and the Supreme Court was right when it said there is this statutory authority. So let's look at the statutes. Now, the two principal statutes that the special counsel and the Department of Justice for decades has relied on are Section 515 and Section 533. Section 515 is an old statute. It goes back to the 1870s when the Department of Justice was first created, and it gives the Attorney General to take certain actions with respect to any attorney specially appointed by the Attorney General under law. The text of the statute is a little bit complicated, but the special counsel argues that this statute does and always has for 155 years now given the Attorney General the authority to appoint these specially appointed attorneys. Section 533, I think, is textually about as clear as you can get. It says, quote, "The Attorney General may appoint officials to detect and prosecute crimes against the United States." And so the argument here is that the text of that statute, Section 533, gives the Attorney General the power to appoint officials, including the special counsel, to prosecute crimes against the United States. And according to the special counsel, that satisfies the requirement in the appointments clause that the Attorney General be vested with the power to appoint the special counsel.
Josh, anything to add about Jack Smith's arguments, as Matthew so clearly summarizes it? First, that U.S. v. Nixon covers the question, and second, that these two statutes, 515 and 530 clearly authorize the appointment of the special counsel. And then, if you like, you can start to respond to whether or not you think that Nixon and the statutes cover the case.
Sure. So I think everything goes back to Nixon and Watergate. Always seems to do that in modern era. What's unique about the Watergate situation is the nature of this position. Believe it or not, it was actually Robert Bork. Yes, the Robert Bork, who did again the Supreme Court, who was acting Attorney General at the time. And then he appointed a special counsel to look into the Watergate issue. And what's sort of unique about that position is what kind of power he gave it. If you read the order, he gave Robert Bork gave the broadest possible powers imaginable. In fact, Bork said the only way that this special counsel be fired is if several members of Congress concur in the termination. What? Yes, the AG gave the removal power over to Congress. But we know from a later case called Boucher v. Sinar that you can't do that. Right, that Congress has no power in removing executive branch officials outside the impeachment context. And that's sort of important. If you read the Nixon decision, there's a word that appears over and over again, unique. Unique, unique, unique. It says, this is limited to these unique circumstances. And Jeff knows very well what a ticket good for one ride is. Think of Bush v. Gore. Very often the Supreme Court tells us, this decision is limited to these facts. And we're telling you this. And the court says unique, unique, unique. So we have here's a role in Nixon. Whether it's holding or dicta, I actually don't really care very much. Let's assume it's a holding. It's a holding limited to a very unique set of facts, which were later abrogated by cases like Boucher. So whatever Nixon held, I think it says nothing at all about this different regime under a different set of appointment clause jurisprudence. I think just it says nothing at all. So Judge Cannon went along with the dicta holding argument. I don't think that will get much sway above, but I think the argument that Seth Barrett-Tillman and I put forward in our brief may be appealing to the 11th Circuit. On the statutory issue, we didn't actually make this argument, but I'll do my best to describe it. This was advanced primarily by a brief on behalf of Attorney General Meese and Steve Calabrese and Attorney General Mukasey and Gary Lawson and a few other scholars. They make a few points. I don't want to bore people with yucky statutes. I know this is a Constitution podcast, but one of the points is that one of the statutes that Matt mentioned is actually a section concerning the FBI, and that this is not really an FBI provision. The word prosecute, you might think, oh, that means indict someone. Well, that actually has a meaning that might mean to actually investigate and actually to go through the nature of a crime. But I actually don't think those fine points matter much. What's significant here is that Jack Smith was appointed from outside the government. And if you go through a number of the various special counsels over the years, there are people who were within the government who were just given additional powers. And I think that, for example, if the sitting United States attorney for the Southern District of Florida was made a special counsel, this argument sort of goes away. What's unique about Jack Smith, and also, I guess, Robert Mueller some years ago, was you had a person outside government but no pre-existing office. And what they're saying is you can't use the statute to give the significant power of an officer to these outside people. So even if there's some statute authorizing some prosecutor, it can't be the power that Jack Smith himself exercises, which is a vast power. He indicted Trump, and it's not even clear that Merrick Garland signed off on the indictment. He sort of hedged on that question during the argument. So all the stuff about the particulars of the statutes are most secondary to what sort of powers are being assigned to him.
Matthew, how sweeping is Judge Cannon's argument? Does it call into question only special counsels appointed outside the government, as Josh describes it, like Jack Smith and Robert Mueller? Or would it call into question the Nixon special prosecutor? And to what degree is this supported by precedent or not?
The decision is sweeping in some respects, but it is limited in the way that Josh indicated. And the reason why is because there isn't a serious dispute that the Attorney General has the authority to take an already existing employee or other officer, official in the Department of Justice and make them into a special counsel. And so the decision is limited in the sense that it applies only to these circumstances where a special counsel is hired directly from outside the government. Now, as Josh indicated, that's happened before. So Special Counsel Robert Mueller and also Special Counsel Robert Hur, who investigated